Both the First Amendment of the United States Constitution and Article Section 10 of the Colorado Constitution protect both freedom of speech and press. Have you ever considered the difference between the two? Webster's 1828 dictionary defines speech as the faculty of uttering articulate words or sounds. Ms. Smith isn't planning to utter articulate words or sounds in her business, but publishing websites, which, according to Noah Webster, is freedom of the press, which is defined as the art or business of printing and publishing. While Ms. Smith, and for that matter the Supreme Court, sees this as a First Amendment freedom of speech case, it's really a Colorado Constitution freedom of press case and a 14th Amendment privileges and immunities case. To clarify her rights, Ms. Smith filed a lawsuit in federal district court. In that suit, she sought an injunction to prevent the state from forcing her to create wedding websites celebrating marriages that defy her beliefs. To secure relief, Ms. Smith first had to establish her standing to sue. That required her to show a credible threat existed that Colorado would, in fact, seek to compel speech from her that she did not wish to produce. Ms. Smith, having seen what happened to Jack Phillips and probably others, initiates a preemptive strike, filing a lawsuit and seeking an injunction against the state of Colorado before they've had a chance to infringe on her rights. However, since she has not been aggrieved yet, she doesn't have an obvious standing for the courts. Generally, courts don't appear to like preemptive lawsuits, deciding to wait until someone actually suffers some harm before accepting them. In order to show that she had standing, Ms. Smith had to show a credible threat that the state of Colorado would compel her to publish websites that she did not want to produce. In her lawsuit, Ms. Smith alleges that if she enters the wedding website business to celebrate marriages she does endorse, she faces a credible threat that Colorado will seek to use CADA, the Colorado Anti-Discrimination Act, to compel her to create websites celebrating marriages she does not endorse. As evidence, Ms. Smith pointed to Colorado's record of past enforcement actions under CADA, including one that worked its way to this court 5 years ago. See Masterpiece Cake Shop. Did Ms. Smith have a credible threat that Colorado would compel her to produce websites celebrating marriages she does not endorse? Absolutely. All the court had to do was look at a previous case it had dealt with. Masterpiece Cake Shop Limited versus Colorado Civil Rights Commission.